Welcome back. I'm John Avisosha, and this is Further Study Family Law, where this season we're exploring the laws that shape families one topic at a time. Marriage is one of our oldest institutions, older than nearly all major religions, and definitely older than any modern legal system. It has been shaping humanity for thousands of years. Long before courts or contracts, we had marriage vows to help codify relationships. Marriage lets you share property, make medical decisions for one another, get certain tax benefits, share information in confidence, have presumed parental rights of children, and much, much more. Maybe you grew up dreaming about your wedding day, or maybe you've decided it isn't for you. Whether you find marriage sacred, outdated, or just straight up complicated, you are not alone. But no matter your opinion, this issue does impact you. It's clear that marriage requires further study. Let me take you back to 1764, when American revolutionaries John and Abigail Adams were married. John and Abigail were America's first power couple, like Bennifer or Brangelina. They were John-a-Gail. John-a-Gail's relationship was unusually modern. Abigail was John's closest political advisor. Their household was also only one of two in history to contain both a sitting U.S. president and a future U.S. president, John and Abigail's son, John Quincy Adams. When people think of marriage, they often think of famous traditional marriages like these. Maybe the royal wedding comes to mind, or the famous string of wives that Henry VIII went through. We're used to the ceremony in a church, parents and family present, tin cans on the car, and a honeymoon to Bora Bora just around the corner. But perhaps you don't think of a wedding at all. Maybe what comes to mind isn't a bouquet toss, but a simple agreement. No rings, no church, just two people choosing each other. Benjamin Franklin and Deborah Reed had a common law marriage that began on September 1st, 1730. They didn't have any civil or religious ceremony. Rather, they simply announced that they intended to live together as husband and wife. Perhaps old Benny was too busy inventing the lightning rod to plan a wedding. The beauty here is that both these relationships received public and private recognition. And like the societies of their time, humans throughout history have worked very hard to find creative ways to express love. What we define as marriage today isn't what it was 100 years ago or even 20 years ago. Laws have had to keep up with changing realities like same-sex marriage or shared parenting time between unmarried partners. Or had to determine financial support for the 13 children you've had with 4 women, most of whom you barely spend time with. What we call traditional marriage today is really just one version of marriage, one chapter in a book with a long history that's still being revised and updated. As ideas about marriage changed over time, so did the systems that govern them. To understand how family law took the shape we recognize today, we need to understand one of the most influential legal systems in the world: English common law. Common law is judge-made law. That means it evolves on a case-by-case basis and therefore changes over time. If you've ever heard someone saying a case has set a new precedent, they're referring to one of the key features of common law. Now, with marriage, the most important thing for you to realize is when you get married, you are opting out of the title system. The title system, more generally, is simply the body of law that says who exclusively owns stuff. Your car, your house, your poodle's house, all of it. That's why it's often called title to property, or in layman's terms, ownership. It's a hugely important system that, of course, we have no time to get into right now. When you get married, it is generally assumed that you now share rights to everything. That boat you bought yourself, you actually bought your wife half a boat. That watch you got her for Christmas, you actually bought yourself half a watch. That half a sandwich you're saving in the fridge, you only own a quarter. This is critical to understand because this concept applies to everything: your salary or any other assets you acquired during your relationship. Real estate, cars, pretty much all of it. Founded a startup with your college buddy and now you're getting divorced? Your spouse now might have an interest in half of your ownership and your voting power in the company. Keep this in mind when getting married. If things don't work out, your lawyer will have to tell you that your spouse has a claim to literally everything you have, even if the spouse didn't directly earn it. We've had that conversation many times with our clients, and it's not fun. There is a solution to this problem, but we will be covering nuptial agreements in another episode later this season. But I still wanted to draw attention to this issue because so many married couples tie the knot without ever having a thoughtful conversation with one another about their finances and the implications of getting married in general. It's really something we should think about more often. Marriage isn't just about the tax breaks, combined health insurance, or the stand mixer you put on your registry. Let's talk about one of the unknown superpowers of marriage: spousal privilege. Generally speaking, sharing information with your partner is similarly protected as sharing information with your attorney. Your marital communications are confidential. Now, there is some distinction to be made between spousal testimony privilege and spousal communication privilege, but we are going to oversimplify here. Spousal privilege is why in Better Call Saul, when Kim Wexler visits Lalo Salamanca in jail trying to find Jimmy's whereabouts, she correctly tells Lalo that Jimmy hasn't betrayed the cartel's confidence by sharing his plans with her. But John, I hear you yell in my fevered imagination, how can communications be privileged if spouses testify against each other in court all the time? If you and your spouse are suing each other, or if each partner is on opposite sides of a criminal proceeding, spousal privilege tends not to hold water. Similarly, some spousal privilege does not survive a dissolution, so if your partner is suing for a divorce, claiming the relationship is already ended, family court is probably going to be a free-for-all. But that said, the argument for the existence of spousal privilege is pretty compelling. As a society, we have decided that some relationships are simply too important to expose in court. You should feel empowered to share everything with your spouse, in good times and in bad. Relationships where each party had to watch everything they said to one another for fear of liability would probably be a pretty shallow dynamic. Imagine pleading the fifth whenever your spouse asks you about your day. I want to jump into talking about jurisdiction and venue, understanding where divorce will take place. It's one of those words you've probably heard but might not really understand. To simplify, jurisdiction just references what government body or court is responsible for and can decide the thing. The thing varies. It could be enforcement of laws, government functions, or court cases. There are two main types of jurisdiction you often encounter: subject matter jurisdiction and personal jurisdiction. Subject matter jurisdiction is simply whether an issue can be heard by a court, whether that court has the inherent power to resolve XYZ dispute. For example, federal courts are courts of limited jurisdiction, only hearing federal questions, disputes with parties from different states, or disputes between states themselves. Courts of limited jurisdiction also tend to derive their power from a specific statute or article, and must stick to their lane pretty rigidly. State trial courts, by contrast, have a lot more flexibility in the general issues they can adjudicate. Really, they can exercise power over pretty much anything within their borders. Their subject matter jurisdiction is far broader. Personal jurisdiction just means what authority an entity or person is subject to. I work in Washington and reside in Washington. Washington courts have personal jurisdiction to oversee any civil claims against me, or to oversee any potential criminal prosecution the state may bring against me as well. Similarly, you are subjected to the laws and jurisdiction of any state you live in or travel to. Physicality has a big impact. For family law specifically, state courts have jurisdiction over any spouse that wants a divorce while living within its borders. The laws framing a divorce are dependent on where you begin to separate, not where you originally got married. When someone is in a state, it is safe to assume they are subject to its laws and courts. This is distinct from venue. Venue references what location a case should physically be heard. For example, if all the parties are in King County, then the King County Superior Court would probably be the appropriate venue. If everyone is in Spokane, Washington, the Spokane County courts would probably try it instead. Both courts have subject matter jurisdiction to divorce people, but for reasons of convenience, one venue is clearly superior to the other. When determining jurisdiction and venue in family law, a good rule of thumb is to look to where everyone resides or has spent the most time in the last 6 months. Even then, things get complicated, as it is conceivable that multiple jurisdictions could lay reasonable claim to a case simultaneously. Like if you and your spouse move around a lot, or if you are physically separated and live in 2 different places. The important thing to know is that deciding where to divorce or what laws your separation is subject to can be tricky. If multiple states could conceivably have reasonable competing claims, the opening moves of your case will be spent evaluating and then fighting about which bench will control, which in turn will have huge implications for the specific outcome. Talk to a lawyer, guys. So what have we learned? Marriage isn't just a romantic commitment. It's a historical tradition shaped by power, religion, and the courts. It bestows privileges, powers, and rights, and impacts how property is owned in a household. Whether you're considering a marriage or thinking about walking away from one, you now know that you might have options between different jurisdictions and venues. What the law considers a legitimate marriage, who's protected by those laws, and which courts have the jurisdiction or power to decide that, well, it's all still evolving, hopefully in the right direction. That's why understanding the law isn't just for lawyers. It's for all of us. In our next episode, we'll dive into divorce and ending marriages. Thanks for watching this episode of Further Study, which was filmed at our studio in Toronto, Canada. Support Further Study on Patreon to keep our content free for anyone who wants to learn. We'll see you next week, guys. Thanks so much.